Good morning. Thank you for being here bright and early after your festivities last evening. I'm David Horrigan, eDiscovery Counsel and Legal Content Director at K-Cura, and welcome to the United Nations of TAR. If you've read the description of this session, you probably know why we've called it the United Nations of TAR, because we have the 4 nations that have adopted and approved judicially technology-assisted review, thus the United Nations of TAR. And when I first came up with this concept, my idea was that I would moderate it, and then I'd get one person from each of the 4 countries. And then I thought, why in the world do I need to moderate this? You don't need Horrigan to do an international panel when you have the one and only Chris Dale. The panel we've got for you today are 3 preeminent jurists and lawyers who have argued the cases that have made technology-assisted review part of everyday life, almost in the United States now in eDiscovery, and it's getting there in Ireland, the United Kingdom, and of course now in Australia. Starting at the end, Karen Hardy is with us. Karen is a partner at McCann Fitzgerald. She was the partner who was in Bet the Company litigation, and I've heard her say before, you know, it wasn't necessarily a popular decision, but she had the courage to do the right thing as far as advancing technology in the law. And she is the one who got technology-assisted review approved in Ireland. Please join me in welcoming Karen Hardy. As for the gentleman sitting next to her, I said it yesterday, I've said it in previous years, I'll say it again. We welcome the Honorable Andrew Peck, the grand poobah of technology-assisted review. And many of you have heard Judge Peck speak before. He, of course, had the 2012 De Silva Moore opinion that really opened the floodgates on technology-assisted review acceptance in U.S. courts. But he didn't stop there. He's had more decisions, most recently, perhaps, Hiles v. City of New York. And he's basically a rock star of TAR. Please welcome the Honorable Andrew Peck. And it is a real honor and privilege to welcome our next speaker as well. He has come halfway across the world to be with us. He is the Honorable Justice Peter Vickery of the Supreme Court of Victoria in Australia. What makes his honor significant here is that he was the judge in the opinion in McConnell Constructors v. Santam, which was the case that approved technology-assisted review in Australia. In addition to the McConnell Constructors decision, the judge has also been involved in setting practice standards, a directive and a practice note in Australia for the proper procedures in TAR. And of course, our last speaker needs no introduction as well. Chris Dale is the founder of the e-Disclosure Information Project in the UK, the 4th nation to approve TAR, the 3rd in chronological order. Chris is a ubiquitous figure at e-Discovery conferences and legal conferences whenever the subject of technology-assisted review comes up, and of course, especially with the international angle. He travels the world to share his knowledge, and it's an honor to have him with us here today. Please welcome Chris Dale.
Thank you, David. 2 things that are common in any such event. One is that we start 8 minutes late, and the other is that the panel is in darkness. This is a feature of US conferences, that the room is always brightly lit and the panel sits in darkness.
It's probably
Don't ask me why. It doesn't make for great videos, I have to say. David was too kind in his introduction. I've spent the last 10 or 12 years helping people with e-discovery, e-disclosure as we call it in the UK, education, and particularly interested in how jurisdictions learn from each other and how we can pick up ideas, which is not an old idea. It's relatively new, particularly in e-discovery, that we've started taking notice of what each other's doing. And technology-assisted review is a subset of a whole wider set of issues where we have been exchanging ideas. When I first came to the US because talking to English lawyers, they'd say, discovery, that's something Americans do, and what an expensive mess they make of it. And I thought I ought to come to the US to find out if that was true, and of course it was. Americans, meanwhile, were sneering at the rest of us and saying, America is 2 years ahead of the rest of the world in all this, which perhaps equally was true. but there's a big gulf there, and yet lots of ideas bubbling away, particularly judicial ones over here, which we rather lacked in the UK. It seemed to me worth trying to carry messages, as it were, between jurisdictions. Privacy and data protection was the other issue where we were poles apart. Americans would back me into a corner at conferences and blame me personally, it seemed. So I felt, from the way they put it, for standing between, because the EU stood between honest Americans trying to do their job as they saw it, and EU protection of privacy. So we started talking about privacy and data protection, and to American audiences who really didn't know what we were talking about. That's another gulf that has narrowed over the years, and we are now talking more about the same things. All this, I knew vaguely this idea that there was a US very broad discovery and conflicting with EU privacy. And one day a US judge came to an English conference, and this was the subject. And he said, well, I say what happens in my court. The Federal Rules of Civil Procedure require parties to hand over all their documents, and if there's an EU privacy problem about that, well, parties generally sort it out before they come before me. And I went away and wrote a furious article about American judicial imperialism, as I called it. The judge was not wrong. That was entirely a correct statement of what his obligations were as a judge in a US court. Good to see you again, Judge Peck. And I resolved to bridge some of these gaps, and Judge Peck and I have been in many jurisdictions together on not just privacy, but on technology-assisted review and on broader concepts of proportionality and this whole idea of learning from each other. In the process of that, I went to Ireland and did a panel with Karen Harty, over on the right there, or left from you, about 8-9 years ago. We talked about predictive coding, as we called it, and at the end, after hours talking about this, a gentleman put his hand up and said, well, what is predictive coding? Which suggested either that we hadn't done hadn't explained ourselves very well since we'd been talking about it for an hour, or he hadn't been listening. But it gives you some idea of the difficulties that we face. Back to technology-assisted review, the subject we're supposed to be on. In October 2011, I was at a conference at Carmel up near San Francisco, and Judge Peck was the main speaker. And as he started speaking, it occurred to me that this was, as it were, a seminal speech. This was a ground moving under our feet speech, because he was talking about the potential for judicial approval of technology-assisted review, which no one had really talked about. And I started typing furiously because every word seemed to me to be important. And I immediately dictated an article saying, the world's changing. We're getting judicial ideas about the use of this kind of technology. And afterwards, Judge Peck came up to me and said, how did you get a verbatim copy of my script? It was so good, it was so obviously the herald of change that it seemed worth typing it up in full. That, in due course, turned into his article, Search Forward, and then into De Silva More, which he'll tell us about in a minute. Since then, other jurisdictions, all of them citing Judge Peck and saying, if it's all right with him, then it's fine by us, or words to that effect, have, as David said at the beginning, have picked up these ideas. A slight deviation, predictive coding, technology-assisted review, analytics, all these terms get thrown around. I'm going to read you Maura Grossman's definition of technology-assisted review, because that's what we're talking about here. A process for prioritizing or coding a collection of documents using a computerized system that harnesses human judgments of one or more subject matter experts on a smaller set of documents, and then extrapolates those judgments to the remaining document collection. That's the definition that we're adopting for these purposes. Judge Peck has said technology-assisted review is the term I'm going to use, and somebody's at least stuck a flag in the ground and said that. Every other judgment in all the other jurisdictions have treated predictive coding and technology-assisted review as if they were co-equal terms. They meant the same thing. Actually, I don't care what you call it, as long as you go and see examples of it and consider using it. Let's start with Judge Peck. Can you give us a how did we get to where we are type brief summary, Judge Peck?
Sure. One quick thing, definitionally, predictive coding was sort of the starting words here, However, back in the 2011-2012 period when I was about to write De Silva Moore, a particular vendor, not the host of this conference, was claiming they had a trademark in the term predictive coding, so we started coming up with CAR and TAR, computer-assisted review, technology-assisted review. And that has led to at least some problems because people use TAR as a synonym for predictive coding, exactly the definition Chris just read. But others think that technology-assisted review is an umbrella term that would cover keyword searching and anything else. And some wag said at one point, it's hot in the summer. If I turn the air conditioner on while I'm doing manual review, is that technology-assisted review? Because I do it better when I'm not sweating. But no, technology-assisted review, as we are using it here, is predictive coding. For the one person in the audience from Karen and Chris's European talk who might still not know what we're talking about, for those of you who use Pandora and you put in, that you like Billy Joel, and then Pandora will suggest, well, okay, if you like Billy Joel, how about this song from Elton John? Give it a thumbs up or a thumbs down. Oh, you've given it a thumbs up. Okay, we'll include that in your playlist. What about some heavy metal band? You quickly give that a thumbs down. And Pandora learns what you like to listen to. And that's exactly what predictive coding is. You train the system, and we can talk about later on the difference between simple learning, TAR 1.0, and continuous active learning and the different training. But an experienced lawyer codes documents as responsive or non-responsive, inputs that into the computer learns from that and gives back to the lawyer some more documents and says, okay, and here's where the prediction is in. I am predicting based on your training that you, the lawyer, would consider these documents to be relevant and responsive. Am I, computer, correct? And the lawyer then verifies, and the computer keeps learning and gets more and more accurate, and the result of which at the end is a prioritization of the most relevant documents to the least likely to be relevant, and at some point, with appropriate QC and quality control, the lawyer can stop the review and say, okay, we've actually found 90-something% of the responsive documents while only having to review 20 or 30% of the documents, and we know everything else is, with quality controlling, not likely to be relevant. That's the way it works. As Chris said, I gave a speech at Carmel Valley. It was one of the few cases where I agreed to do a keynote where I actually had to talk for 45 minutes to an hour without somebody throwing a question at me, when I usually don't like to do that. I was asked, I said, okay, what do you want me to keynote about? And they said, how about the history of search and where we are now? That led me to doing some research, talking about it, which led to my Search Forward article in Law Technology News. And then within a few months of that article, as I famously said at the time, the folks in the De Silva Moore case were referred to me by the district judge on the case, and I said to at least the party that more than the other wanted to use predictive coding, oh, when you got assigned to me, you must have thought you died and went to heaven, since I know something about this subject. So in De Silva Moore, while both sides were agreeing to predictive coding, it was sort of the, at least on the plaintiff's side, I'm agreeing to do it, but only if the other party uses my protocol. And if they don't want to use my protocol, I'm going to take my ball and go home. And I ruled that the other side could indeed do it their way, and that the plaintiff could not just withdraw from the field, but that the responding party, the publicists and MSL side, could use predictive coding. And I said that, for those who have been waiting for judicial approval for this because I knew lawyers had been using it or considering using it, well, you now have formal judicial approval from the De Silva Moore decision. They appealed my decision to the district judge, as was their right, and he affirmed what I did. I think I will stop there, Chris.
Well, if we just move on straight into Rio Tinto, if you would, and your black letter, just very briefly to the black letter point.
So between De Silva Moore and Rio Tinto, there were 20 to 30 cases dealing with predictive coding in one form or another in the United States. Rio Tinto, which was my second of the trilogy of U.S. tar cases that I wrote. And it gave me an opportunity to say, okay, we're now 3-4 years later, and by now it is black letter law that if the responding party wants to use predictive coding, it will be free and the courts will allow it to do so. It is free to do so. And I think that is indeed the state of the law in the United States at this time. I will call out a shout out to the Sedona Conference Working Group 1, which published a few months ago the Sedona Tar Case Law Primer, which is a description of all the U.S. tar cases up to that point, and indeed the international cases up to that point. It's available for free at the Sedona website, thesedonaconference.org. So if you want to know the cases beyond the 3 that I wrote in the United States, that's where you'll find it. Do you want me to do Heil?
Can I do Heil's, in fact,
Sure.
if you don't mind doing that? A further case, Heil's against New York City, involved one party effectively wanting another party to be compelled to use technology-assisted review. And you'd expect, as many people expected, that Judge Peck would say, yes, of course, black letter law. If you want them to use predictive coding, technology-assisted review, I'll make them. He did not reach that conclusion, partly because of a Sedona principle, but partly saying, with some regret in his voice, that the law had not yet reached the stage where one party could be forced to use technology-assisted review or indeed conduct their discovery by using any particular technology. I wrote an article based on that said, I wonder what an English court would have done. And I think an English court would have compelled the use of technology-assisted review in such a case, if that was the most proportionate course. Justice Vickery, do you think that would have been your response?
Yes, we've got a well-developed Civil Procedure Act which came into operation in 2010 in Victoria. That effectively provides the springboard for compulsory directions in relation to discovery. And what we've done, founded upon that, in our practice note, is actually require that to be the position where we say technology-assisted review may be ordered by the court whether or not it is consented to by the parties. So we've defined the position.
Excellent. I wanted that just interjection into to Judge Peck's line, because I was reasonably sure that was the answer I was going to get out of you. So we have he helped write
I've deferred to the Secretary General.
You sense a different approach between the US and the rest of the world, where the rest of the common law world, where we are more likely to have a judge say, if this is the most proportionate course, if this is the way that's going to save money, then I will order that it happens, which it contrasts with the position that Judge Peck felt he had to take in Heil's.
Chris, I wonder if that's because in most of the Commonwealth countries, there is the losing party pays costs.
Could be, yes.
While in the United States, each side is bearing its own costs. So if the responding party wants to be inefficient and spend its money in a silly way, we might let them do that.
Indeed.
Speaking from the perspective of a small, wet, windy island on the western edge of Europe, we're not a Commonwealth country. And I think
Once again, I've made a mistake in
that's all right.
cross-border relations.
That's okay. I won't hold it against
We
you.
don't want an international incident here.
No, might be a bit of fun actually if we
But
did
you
have one.
derive your discovery rules from the same source as the rest of us, I think.
Yes,
is the
that's
main
true.
point.
But I think judges in Ireland would not force a party to use technology-assisted review. We're not at that stage yet.
Okay, that's
I might say that although we have the rule, it's not invoked in practice. I haven't used it yet, but having the rule there encourages the parties to agree. In other words, they know that if we are recalcitrant in this obviously useful mechanism, that we might get costs awarded against us ultimately, or the court could order a compulsory use of TAR.
One last point from Judge Peck, we'll come back to him anyway, but in this theme, you mentioned to me the other day that you're finding fewer and fewer people arguing about it in your court, and you're assuming that that's because they're simply agreeing, at least with the principle of using technology of some kind or another, and therefore not having anything to bring to you to argue about.
Correct. I see it in just their passing remarks at a discovery conference or a Rule 16 conference. Yes, we're both using TAR, or one of us are using TAR. I also think that that may well be the implication from the fact that there have been fewer judicial decisions in the U.S. on TAR-related issues, but, there are lots of people sitting in rooms like this at conferences who are using TAR. So I think it's still not the majority usage by any means. It's still mostly keywords being used, but we are seeing more and more use of TAR, at least anecdotally, without fights about it.
Thank you. Karen Harty, let's move to the wet, windy island, as you called it, off the west coast of Europe. Ireland, where they take discovery very seriously and fight about it a lot. Can you take us through the Quinn case, your involvement in it, and the upshot?
Certainly. The first thing I should say is the Quinn litigation is still active, so I'm not going to say much about it other than to just tell you factually what's a matter of public record. Discovery is probably fair to say it's a national sport in Ireland. It is a very aggressive strategy in most cases to root out what the other side has, and to, I'm afraid to say, in some cases, damage not only the opponent but the opponent's lawyers by way of suggesting that they might not have handed everything over, they might have hidden things. So it's high-stakes stuff.
There's a high test and hotly fought battles.
Yes, we still have the old Peruvian guano relevance train of inquiry standard, and it is fully fought, which is why I enjoy it so much. But if I was being honest, I
can just interject there and say, when I was told I was going to do a panel with Karen Harty, somebody said, "You're not going up on a platform alone with her, are you?" because her reputation in Dublin, even then, and this was 8 years ago, was for being very, very competitive.
I have no idea what you're talking about. Now, the Quinn litigation, I suppose we had been using computer-assisted learning system, actually, for investigations. And I knew it was accurate, I knew it was good, and I didn't know why it wasn't being used in discovery. And so for this particular case where we had a very large data set, I suggested to the client that we should look at using technology-assisted review on the 1.0 model. And the client was understandably nervous about making new law. No client likes to make new law. And they said, well, who else is doing it? I said, nobody. The Americans are doing it, but they don't really count. And in the end, we were facing into a very, very long and large discovery process, and it just didn't make sense not to try it. So we decided that the thing to do was to bring an application for approval from the court, to keep ourselves right, and to say to the court, this is how we're doing it. And it was fully contested. The other side took what I think they would probably accept was a flat earth position in relation to it, and said, you're just not entitled to do this because it involves you not looking at every document, and it involves you possibly missing relevant documents. So on that basis they objected. It went to full contested hearing with expert evidence. And we had a technical expert, and we also had a practicing attorney from the US who had used it on cases, and he gave very compelling evidence. And ultimately it got approved. It was then appealed to the Court of Appeal.
So evidence and citations from, amongst others, Judge Peck. And
yes, I mean, the Grossman McCormick study was heavily relied upon, Judge Peck's judgments in De Silva, and resulting in a wrinkle, which I will come on to, by the way, to do with transparency. We might talk about that later. But I suppose what has happened since then, so we're talking about the Court of Appeal approval was in 2015, so we're now 2 years on from that. My sense is that in Ireland, TAR is becoming more commonplace. Parties are using it. And there haven't been any more contested applications in relation to it, which I think is a good sign. The question of the transparency side of it is very much, I think, the focus of debates at the moment, and I'm happy to talk further about that at the appropriate time.
Well, perhaps we'll come back to that when we've been through the history, but there's one other point from the Quinn judgment that caught my eye when I first read it, that the court took a fairly dim view of the flat earth approach taken by your opponents. There was a sense as one read through it that the court wasn't impressed by their failing to get up and debate the point properly.
Yeah, I suppose we had organised a meeting with them, which is very unusual in the context of Irish procedures. Normally, the sort of the US meet and confer concept doesn't apply in Ireland. But we got them into a room with our experts, and we tried to explain to them what it was, that it wasn't witchcraft, that what we were proposing was actually accurate and reliable, and so on. And there were points that they just didn't get. For example, the relevancy percentage, the likely relevant percentage, if you can call it that, they thought that meant the percentage of the document that was likely relevant, as opposed, I mean, it was really tortuous, to be honest. But in fairness, they had a job to do as well, and their job was to do the opposite of what I wanted. So I think from the court's point of view, there was a very strong signal from the Irish courts that if the technology is there and it's reliable, you should be using it. And there have been some noises around the possibility of parties being penalised on costs if they don't use technology that's available and take advantage of the expertise available to them on a very large project, that the other side, because we have cost shifting, might not be visited with the costs of that. And I have been involved in a case recently where we have a perception that the other side's spend on discovery is much, much higher than it needs to be. And we will certainly be taking that issue when it comes to fighting about costs later on.
Thank you. There was one of the things that came through on the appeal in Quinn was the court's willingness to adapt rules, not to change rules or break rules, but to extend the meaning of rules where it was necessary to adjust to modern times, which again we see, and I think we'll hear much the same about Victoria in a minute. Very briefly, I'll talk about what happened in the UK. For years, technology of this kind the use has been agreed between parties and approved by judges in the normal course of events. But we don't publish every judgment of English courts, particularly procedural things. So it was perfectly plausible for lawyers to say, no judge has ever approved this technology, the same point as Karen made, so I'm not going to agree its use. And we needed a judgment, an authoritative judgment, to help us move things forward. We got one beginning of last year, in a case called Pirro. And some of you may remember that last year I brought the two protagonists from Pirro here to Relativity Fest to talk about, from the two firms, to talk about how they had arrived at their conclusion. And if you read the judgment in Pirro, it all looks very lovey-dovey. It looks as if they got on very well, and there's a nice neat 10 points at the end where the judge said this is the reason why this is the right thing to do, and so on. In fact, they fought like cats all the way through certainly the early stages of that litigation, defending their clients' interests. And it wasn't until one of them said, and this picks up on something that Karen's just said, let's get in a room and talk about this with our experts. And they did that, and they decided that technology-assisted review was the way forward. There were many difficult things to get over after that. They fought quite a lot. And I think it was only, in fact, the day before the judgment was delivered that they finally agreed on what the terms were. Nevertheless, we ended up with a judgment with these nice, neat 10 points in support of the use of technology like this. A consent judgment, which is effectively what this was, or a consent order of this kind, is not perhaps quite as helpful as one that's been fought over. And a few months later, we got one in a case called BCA Trading, where one party wanted it used and the other one didn't. And the judge in that case concluded that predictive coding would be used. He adopted the 10 points, or 9 of the 10 points from Pirot, and said, predictive coding must be the way forward, was the line he took there. It's now reasonable to say that you'd have an uphill fight in a case of a suitable volume and suitable types of documents to argue in an English court, in Court of England and Wales, should I say, that this technology was not to be used. It's been a significant boost for the use of technology generally, actually, not just technology-assisted review. Meanwhile, in Australia, always actually rather more forward than we have been in judge-led management of cases, things were happening. Justice Vickery, could you give us very briefly a look at what's different between the Australian and Victorian systems and the American one, to the extent that that will help people illuminate that you're coming from a different place?
Yes, I do come from a different place. Our continent is an island which is hot and dry.
Go on, rub it in.
You weren't expecting all this geography, were you?
I was able to develop further, I think, at least in Australia, the use of TAR through a case I decided called McConnell-Dowell against Santam. This was a large case involving a pipeline in Queensland, which gave rise to some 4 million documents which needed to be managed, and TAR seemed to be an obvious choice of technology to control and manage this in a proportionate way.
Did you initiate that discussion, or did one of the parties initiate it?
No, I initiated it in one of our directions hearings. We have regular directions hearings, particularly in large cases, where the parties are compelled to come before the court to outline the procedural steps that they propose to take and what the court thinks is appropriate, and will make orders accordingly.
There's a warning there. Those of you who, and I'm sure it doesn't apply to anybody in this room, but if you don't understand this technology, don't know what it is, don't know what the words mean, firstly, your client may say, are you thinking of using this technology? And that would be kind of embarrassing if you didn't know what it was. Even more embarrassing, perhaps, when you get in front of the court and the judge says, well, you are thinking of using some technology like technology-assisted review, aren't you? Collapse of everybody in embarrassment if it's the judge that's got there first. So applause for that one.
The way I was able to do this was because the parties hadn't initiated it. At one directions hearing, I foreshadowed the possibility of the use of this technology to signal to the parties that on the next directions hearing I might well take it up. So they had time to consult with their clients, consider what TAR involved, and consider the technology and review the costs and formulate a position. So when they came back, they were more amenable to the imposition, if you like, of TAR, and in fact accepted it. So there wasn't an argument, but they had to be coached along to that position. So ultimately it was by consent, I must say. But anyway, I made the decision. It was an unusual decision in the sense that rarely, as in Ireland, do we report interlocutory or procedural matters, but this seemed to be an appropriate vehicle to achieve that. As an educative tool, more than anything, I had the advantage in the judgment of course, Andrew Peck's De Silva Moore case, Pyro and Quinn. So building upon those precedents, I was able to establish the authority of the decision and use of TAR in Australia. It received, I must say, a warm welcome from the profession. It was written up in numbers of articles posted on the internet. So it was hailed as something of an advance in Australia, which assisted in the educative process, which is so critical to the development of TAR.
I was one of those that wrote an article about that because it happened to come out about the same. No, I got my timing wrong there. It was nevertheless an interesting one, mainly from my point of view, for the judge-led nature of it. That was the first factor that stuck in my mind. And secondly, because of something else I'm going to ask you about in a minute, which is the technology practice note. First, though, Judge Peck, I have a sense that a US judge would not necessarily feel it right to self-start on matters like that, or has that changed?
Well, it depends on the judge. You heard the one area yesterday at the judges panel where Judge Rodriguez and I disagreed about what he called the mother may I approach to things. But I do think that one of the instructions that we judges got from the Rules Committee in the December 2015 Rules Amendments was to be more active in case management, more hands-on, and so judges who are familiar with TAR or other forms of technology are likely to ask counsel at the initial conference or subsequent conferences, have you considered using this to save time, save money, etc. But, as with getting the lawyers to adopt the new system, it's not necessarily that all judges are going to jump right in. And I think, there are still a large number of judges in the United States who may have heard about TAR and maybe read, some of the decisions, but are not necessarily sure what it is and would be more likely to need the parties to, educate them in asking for permission to use it or anything like that.
In the English or the Rules of England and Wales, sorry, Phil, I'll come back to you in a minute. In the Rules of England and Wales, there's an express duty placed on the court to manage cases actively. There's also a nice rule that says that the court may do anything that it thinks right that doesn't conflict with any other rule, to which I say, if the court can do anything it wants, can make any order, then you can seek any order, and it's for parties to be more inventive, perhaps, in working out what's right for that case. Karen, are there developments going along in Ireland at the moment along in that sort of area?
Yeah, and just picking up on a point that Judge Peck made about education of judges, I think is really important here, because I think judges will lead this if they understand the benefits of using this technology. I was recently in Abu Dhabi training the appeal court judges of the Global Market Court on technology-assisted review because they felt that they weren't equipped to deal with applications and they wanted to understand what the issues were so that when something came in front of them, they'd be able to deal with it. So that's just interesting. I think I'd like to see a lot more judicial education around this, but that's by the by. In Ireland, we have a new Chief Justice, Mr. Justice Frank Clark, who some of you may have heard of, and he is very interested in e-discovery. He's very interested in technology-assisted review and in technology generally. And it's interesting, he was only appointed in August, and this morning he arranged for the first ever live broadcast of a Supreme Court hearing in Ireland. And that's indicative of the approach that he's going to take. He's going to want to see an awful lot more use of technology, both to save costs, but also to improve access to justice. And I think it's interesting times from the point of view of a practitioner. So I think practitioners in Ireland are going to see judges being more proactive about asking, why are you not using technology, and wanting answers around that.
And that, as I say, places a pretty high burden on lawyers to at least know what these terms mean, so that they're not thrown completely when it's the judge that raises it first, or indeed the client. And don't say we don't bring you the very best. Somebody who pops out to Abu Dhabi to tell the judges how they should be drafting their rules is a speaker we are very lucky to have. Thank you, Karen. Let's move back to Victoria and to the technology practice note, or to give it its proper name, Practice Note SC Gen 5 Technology and Civil Litigation. Justice Vickery, will you tell us something about the genesis of that and the effect, and with specific reference to the use of technology-assisted review?
Yes, the genesis was to do two things with regard to TAR. Firstly, to provide something of an educative tool for the legal profession. TAR is new to us, or new to many in the legal profession, so the primary goal was to provide, if you like, an educative tool or an advertisement that TAR exists, here it is, take note of it, consider its use. So we've used it in that way. But the second facility provided by the practice note was to provide something of a checklist for parties who may be unfamiliar with the development of the necessary protocol for TAR use. In other words, we've set out a smorgasbord of things to consider. It's not prescriptive in the sense that you must do these things. It's rather a selection of things to consider in developing a protocol. So it provides something of a checklist. That was its genesis. And with that in mind, we developed a series of design principles in working towards development of the practice note. And the first, if you like, was end-user consultation. Before we developed the practice note, I conducted a series of interviews with members of the legal profession, some judges who still regard this as witchcraft or a black art and are very suspicious about it, but nevertheless they were consulted informally. But also consultation was undertaken with TAR experts, and I received some considerable assistance from various members of the technology community. So putting all that together was an important exercise. Like any development of a modern computer system, end-user consultation or an iterative approach to design is critical. We applied those principles in the development of the note. The second element, which was critical, often ignored by draftspersons of legislation, is simplicity. Try to make it simple, keep it simple. And the drafting of the practice note took that in mind. It's not overly technical, it's not designed to confuse or raise questions. It's rather there to present in a simple format what is expected of practitioners engaging in the exercise. I'm reminded of the dreadful tyrant Caligula, who practiced writing legislation by etching it into the top end of columns, which couldn't be read by ordinary citizenry. Drafting of legislation in a complex way achieves the same thing, but the 21st century demands a little more of us than that. So simplicity was a key component. Another element of the practice note is flexibility. We need flexibility for two reasons. One, to accommodate new technologies as they arise, and inevitably will as TAR is developed further. The second is that one needs to have flexibility to adjust to each case. Every case is different. Every case will have different demands and different demands in the field of discovery. So rather than adopt a prescriptive technique, it's rather an inclusive technique. In other words, you may do this, you may do that.
Encouraging that same point as I made earlier, that
yes.
you can go to the court and say, this is how we think this case is best managed.
That's correct, and that's accommodated in this design. It doesn't say you have to do this, you should do this, you must do this. It's rather, consider this, you may do this. So that's the technique in drafting to achieve that outcome of essential flexibility. The practice note commences with an introduction, telling you something about what TAR is, its use and its purpose to adjust to the demands of large document cases and consider proportional costs. And it mentions, for example, in a footnote, the Pyro case, which describes accurately what TAR is about. So with those things in mind, we've developed our smorgasbord, and it seems to be working well.
To come back to the point I made when Karen was talking, if a party were to ignore these things, so they're not mandatory, but they're there as a guideline. If one party were to want to pursue one of your avenues and the other one didn't want anything to do with it, presumably that would count against them in the argument.
Well, those sorts of arguments are not dealt with by the court. What we tend to do is appoint an expert, IT expert, who is independent of the parties, to guide the parties through the process of developing a protocol. So those matters are hashed out, if you like, with the assistance of an independent expert. And if there's a difficulty that arises, the expert can report back to the court and say, we have a problem here, please, it needs judicial review or consideration or determination. That can be done. But it hasn't happened yet. It's usually knocked out in a discussion over the table with the expert.
And Judge Peck, you did something similar in Rio Tinto, I think.
I did, as they were getting near the end of the process with some fairly complex issues on recall, precision, and other statistics. I kept suggesting to the parties that it would be a good idea and that it would actually save them money, even though they would have to pay for a special master. And after enough time, I did convince them and had suggested to them that there would be no better special master than Maura Grossman, who's one of the leading experts in this area, and they agreed, and she wound up working with them and not having to issue decisions as such, because she was able to work through those issues with them, and then the case went away for other reasons, so it never finalized as such.
Any similar moves in Ireland, Karen, as opposed to hiring your own expert? Is there any sense of a court-appointed or court-approved expert?
Very much so. There's been a recent change to the rules which allows for court-appointed assessors along that model. Hasn't specifically happened in relation to TAR as yet, but I think it's only a matter of time. And that might be a good segue into the transparency point that I mentioned earlier, because that's where it's likely to be a key issue. In the Quinn case, in order to get judicial approval, I drafted a protocol which was designed to deal with concerns the other side had expressed about how are you training the system. And we need to have transparency around how you're training the system. And look, Judge Peck and De Silva Moore said you need to have transparency, so we're entitled to see everything you've done. So we had to strike a balance, and we came up with a protocol which was workable for the case. I suppose what's interesting now is that things have moved on a lot since we drafted that protocol back in 2013. And, you know, for example, my team in the office is using a lot of the 2.0 model, if you want to call it that, or 3.0 or 4.0, depending on which vendor you listen to, as well as the 1.0 model. And so TAR is different to what it was back in the Quinn days, although the Quinn litigation is still trucking along. I think it does. This question of transparency is tricky. For example, one of the issues, and just to give an illustration that we had to wrestle with, was they wanted to see how we had trained the system. The output of the seed set and the training sets were a selection of relevant documents, non-relevant documents, commercially sensitive documents, and privileged documents. And they all sort of fell into different categories. We said, look, you're entitled to see what we've determined is relevant out of this. Don't have an issue with that. You can see that. And we'll give you a sample of non-relevant so that you can see the stuff we're leaving out, but you can't see anything that's commercially sensitive or privileged. And they accepted that, except that they wanted to see, as is appropriate under Irish procedures, the list of the things we were saying were privileged. And we said, well, you can see that in relation to the relevant stuff, but you've no entitlement to see privileged stuff that isn't relevant. And so we had a big discussion about that, but we ended up with a protocol which allowed their counsel, as in their barrister, we have a split profession, to look at a list of the privileged non-relevant stuff to satisfy themselves that we had done the thing correctly. And that was a compromise. But it might not be right for every case. And I suppose, you could easily see the court saying, in order to iron out these issues, I'm going to appoint an assessor and you can work it out and then come back to me and tell you what you're doing. And I think that's probably, we're going to see more of that.
Judge Peck, to what extent does a judge need to understand this technology?
If there is a dispute, clearly the judge needs to understand it. I don't think that it needs to be in a Daubert, expert witness capacity. And I said in De Silva Moore that I don't think Daubert, the rule that a qualified expert must testify under the federal rules of evidence, adding that cost to what is essentially a discovery issue is not under Rule 1 just, speedy, and inexpensive. But clearly, the lawyers alone or with their vendor or other expert need to get the judge to understand the process. And one of the things Karen was saying, there is a difference in the training of a simple learning system, the so-called TAR 1.0, where if you are gaming the system by mistraining it, by taking clearly hot documents and saying to the computer, oh, these are not relevant, don't give me any of these, garbage in, garbage out, while continuous active learning, the so-called current TAR 2.0, every document is a training document. In other words, in simple learning, you keep training until the system is stabilized, and then that's it. Then the computer runs through all the documents. Whatever that initial training is, good or bad, is going to determine the results. In continuous active learning, each round you are retraining the system. So if there is a document that is relevant as a seed, so to speak, that is being produced. Every relevant document is being produced, and from that the computer says, okay, here's the next batch of most relevant documents, and it keeps going until the computer essentially says there are no more relevant documents, or until the number of relevant documents or the repetitiveness of them is such that it's not cost effective and proportional to keep reviewing. So some of that transparency question that was an issue in De Silva Moore as well will, I believe, disappear or dissipate under continuous active learning, the more modern flavor of TAR.
Justice Vickery, do the judges in your jurisdiction need to understand how the legs work, as it were?
To a degree. I've recently had to master some elements of TAR which I hadn't understood before when the assessor came before the court with a report indicating a dispute between the parties. The use of TAR in various training rounds had reduced the number of documents in the pool from some 4 million to 180,000, which was a good exercise and useful exercise, of course. But one party wanted to continue with the use of TAR to reduce it down to an objective of some 100,000. The other party disagreed with that and said it was now time to stop. The assessor's opinion was that it was now time to stop. I had to determine that issue and then understand whether or not, in all the circumstances, the likelihood was with further training rounds it would be proportionate and useful to continue with the process. So in undertaking that exercise, I had to understand TAR at a higher level than I had previously.
We have 1 minute to go. I haven't given you notice of this question, but one message from each of you, please. Karen, what message would you give to litigants or their lawyers?
I think you're probably negligent if you're not thinking about using it. It's probably the key message.
Excellent. Judge Peck?
We can learn from each other in each of the various different jurisdictions. And there is no one right answer to any of this, but At the moment, until we get to a new stage of artificial intelligence, TAR does seem to be the most efficient and most cost-effective way to review massive amounts of documents. And there is judicial acceptance pretty much around the world. Use it, or at least consider with your clients the wisdom of using it.
Justice Vickery?
Yes, I take the view that there are two tectonic plates at work here. One is the massive growth or exponential growth of ESI, which is facing and confronting the courts. We need to manage it to undertake our core exercise, which is dispensing justice. The second is the development over the last 20 years or so, since Lord Wolfe's report in 1996, of the consciousness of the legal profession and the law generally as to costs and managing costs. Those two plates, if you like, are combining to produce an answer which for the present looks to be TAR as the appropriate way to adjust the process.
Thank you. My own lies in that quotation I gave you from the English rules, the one that said that the court may make any order that doesn't conflict with any other rule. And the reduced message from that, which is if the court can make any order, you can seek any order. It's down to all of us to work out what it is within the rules that we can seek that will do the best thing for our clients and for the litigation. Thank you very much to my panel. Very good of you, thank you. And thank you very much for coming. And thank you, Relativity, for hosting us.